Baby, close this door for me. Please now. Good evening, everyone. How was your day? Sorry, we are starting late today simply because of some other engagements that we needed to address, and then I was also caught off in traffic, so I couldn't just make it home on time. We were preparing for Enugu induction. Can you hear me? This good evening. Can you hear me? Hello, can you hear me? Good evening, everyone. Can you hear me? All right, since you can hear me, we are going to start right away. So I apologize for starting or rescheduling the meeting an hour, uh, behind schedules. We we were working on Enugu induction materials. Our Enugu induction is coming up on Saturday this week. So we are putting some things in place to make sure that the induction take place. So uh, we didn't finish on time. And of course, I was also caught up with Abuja traffic. So we're trying to navigate our way and get home on time, but we couldn't make it. So we have to reschedule the meeting by 1 hour ahead of time. So, but we thank God that we are here now. And for those of you that participated in emotional intelligence, I hope you have gotten, all of you have gotten your certificate, because I think I've sent the link to almost everybody. But in case you have not received the link yet, you let me know so that the link will be sent to your serial number, rather, will be sent to you so that you can get your certificate. Please, if you have not received the serial number, let us know so that we'll give you the serial number. And for those of you that had challenges all right, can we? So, like I said, if you have not received your serial number for your certificate on emotional intelligence, you let us know so that we can certificate. Because for me, I think I'm almost done with everybody. But if there's anybody that is yet to receive his certificate, a serial number, let us know. And then those of you that are going to write your exams tomorrow, your examination is going to take place by 9 p.m. So do wait to get ready for your exams tomorrow. Those of you that didn't pass the exams in the first place, you are going to, so by the time by 8 p.m. you are going to receive a link, or by 9 p.m. you are going to receive a link for your examination. So if you know, we'll give you direction on what to do. Yes, we'll give you direction on what to do so that you get your the link for the examination. So that's it. Thank you very much. So can you hear me now? Are we together now? So can we progress? All right. Today we are going to look at hybrid approaches in specific context. That's what we're going to look at. Hybrid approach. That is hybrid ADR approaches in specific what context. That's what we're looking at. Please, if you join the meeting, don't forget to share it on your word. Invite somebody to also join you in participating in today's training, or let them know that something like this is happening in the maybe in the next classes that will be coming up. So hybrid approaches in specific contexts. Hybrid approaches in specific contexts. So we'll be looking at the application of hybrid ADR processes in various fields. So we'll mention as many as possible. Then we'll look at the case studies showcasing successful hybrid ADR implementations. Then we'll look at evaluating the effectiveness of hybrid approaches in achieving resolutions. So these are some of the things that we're going to look at today. So, and I hope that you are going to benefit as we navigate through the process. All right. So we say hybrid alternative dispute resolution processes combine elements of different dispute resolution methods, such as mediation, arbitration, and negotiation to effective approach. Do you understand? So now, when we talk about hybrid, we are trying to talk about a combination of different methods of conflict resolution, most especially alternative dispute resolution elements, to resolve conflict in different fields. And so when you are talking about this, you're talking about how you can bring mediation, arbitration, and negotiation together to resolve conflicts. Do you understand? There's something we're supposed to look at, something like made up, that's made up, that's AI and mediation, arbitration, resolution. But I deliberately jump the topic because it covers a lot of certain things that we have covered. So I just ignore it. So, but we have different fields that we can apply a combination of these factors to resolve conflicts. So we are going to look at those areas where we can combine these factors or this method or this element of ADR to resolve conflict. And that's why we call it hybrid. Do you understand? Hybrid processes. Do you understand? So we look at it in commercial dispute. How do you combine these approaches to resolve conflicts or a commercial dispute? So let's look at mediation arbitration. Mediation arbitration, made up. All right. In business contracts, parties may first attempt mediation and, if unresolved, proceed to which can expedite the resolution process while preserving relationship. Do you understand? So now, what this simply means is the mediation arbitration means simply is that, you know, it is allowed that you can try mediation first. So if you are able to resolve your conflict through the mediation processes, you can decide to put in arbitration. Do you understand? You can decide to put in arbitration. And then maybe that will help you to resolve the conflict. Do you understand? Because in a situation whereby the parties are not being able to coordinate themselves to arrive at a resolution that will benefit all of them, you decide to engage the arbitration element. And the arbitration, the arbitrator has total control of the process and takes a binding decision, unlike in mediation where the mediator facilitates only conversation and the parties involved in conflict have absolute control of the process and, of course, determine the outcomes of the mediation process. So, in case such process fails, you decide to deploy the instrumentality of arbitration to help the parties resolve conflict. Do you understand? So you first and foremost attempt mediation. If it did not work, you go ahead and attempt what arbitration. And we say this kind of arrangements basically apply in commercial disputes. Do you understand? Mediation, arbitration. All right. So number two, we have family law. Family law. So we have what we call corroborative law. I think we taught corroborative law here, and I hope you are not forgetting what we say. All right. So corroborative law, couples can engage in corroborative negotiation aided by what? Lawyers and mediators. If the process fails, they agree to seek arbitration or litigation, ensuring a focus on amicable resolutions. So you can see the process. Even in commercial dispute, if in case arbitration also fails, you can approach a court of law for any litigation. Do you understand? So family law, like we talk about corroborative law, it's also work to preserve relationship, and it's much applicable when when you are dealing with either business partners or family. That's people that you have cherished, you have close relationship, and you have cherished and valued the relationship, and you don't want that relationship to be broken. You can use collaborative law. Do you understand? Which is basically applying family law. So if couples are having challenges, they may approach mediation. If it does not work, they approach arbitration or collaborative law. If it does not work, they can approach the court of law or courts to just see how they can resolve their differences. They can deploy the instrumentality of litigation to see how their cases resolved. But the aim is to have to achieve an outcomes that benefit all the parties. Do you understand? So that's the essence. That's the essence. All right. So somebody was asking me yesterday, do we have arbitration laws in Nigeria? Just today, one of the professors I was talking about, I used to connect a meeting, she shared something with me, although I did not have time to go through, where they use arbitration to, like, you know, get maybe a former senator somewhere was leasing a property, and then at some point maybe he did not pay the lease, or he did not even fulfill some certain requirements. So through arbitration, they stripped him of his property in Abuja here. Do you understand? So in Abuja here, in Nigeria. So arbitration. So it seems that it's also functioning here. So we just need to key into it, and we need to amplify it so that we reduce court cases. Do you understand? So that's what we need to do. It's just that it is functioning, but it's not functioning as expected. So we need to amplify it. Do you understand? So workplace conflicts. These hybrid processes can also be applied in what? Workplace conflicts. For instance, facilitated negotiations. In labor disputes, a neutral facilitator can help parties negotiate the terms of agreement. They negotiate the terms of agreement. If negotiations stall, they can shift to mediation. And if mediation did not work, they can shift to arbitration. If it did not work, they can go to court. Okay? But whatever it means, it is for them to achieve a quick resolution, because this is a labor case. And of course, you cannot, if you go to court, it will affect productivity. Do you understand? So when it comes to workplace conflict management, you must try as much as possible to stop arbitration because they help reduce um, wastage of time, wastage of energy and resources that could have been channeled to something that will be productive to the organization and even to the individuals involved. So workplace conflicts can also, uh, this hybrid process can be applied in workplace conflict. And one of those uh, hybrid approaches you can use is negotiated or facilitated negotiation. And then we talk about collaborative law, we talk about mediation and arbitration in commercial disputes, collaborative law in family law, and workplace conflicts. So let's look at international dispute. In international dispute, what approach are you going to apply? We have multi-tiered dispute resolution clauses, multi-tiered what negotiation or dispute resolution clauses. All right. Businesses may include clauses that require negotiation, followed by mediation, and finally arbitration. Do you understand? So we have a multi-tiered. I think you understand what I'm trying to talk about. A multi-tiered. That's we have tiers of government. Let me just give an example. Tiers of government, right? The the legislature, the executive, and the what? The judiciary, right? Or there's what we call the state, the local government, and the federal, right? So this is what we call a tier. All right. So we have multi-tiered dispute resolution clauses. So in a particular international trade, the parties may decide to put some of these clauses in the agreement so that in case there's any form of dispute in the course of interaction or in the course of business interaction, we can decide to approach negotiation first. Now, if negotiation fails, we can use mediation. And then if it fails, we can use arbitration. Do you understand? So the essence is to see how possible you can resolve your conflict as much as possible to forge ahead with your business transactions. Do you understand? So that's why I talk about negotiation because negotiation can be done within 2 3 days and you're done. Do you understand? Depends on the complex or the complexity of the case or the nature of the case you are dealing with. Okay, and then mediation. You see, that's why even arbitration is the last because arbitration can take a little time more than mediation and negotiation. Do you understand? So you can put some of these clauses in the agreement so that in case of any disagreement, you can revisit some of this and deploy some of these approaches to resolve your conflict, hybrid approaches. So in construction industry, that is construction and real estate. For those of you that are into construction and real estate business, all right, we have what we call dispute review boards, DRBs. Dispute review what boards. So in construction project, a panel can provide ongoing advice and mediation during the project. If dispute arises, they may transition to arbitration for final resolution. All right. So we can set, in project management, for instance, now in project management, for instance, we have what we call the governing board. Do you understand? The governing board, the project governing board. Do you understand? And this board make decisions because it comprises of all the stakeholders that are concerned so far as the project is concerned. You have a project governance board. So the board takes the responsibility of some of these things, even the dispute. If there's any dispute, you report to them. The project manager that is the site engineer can report to project manager. Project manager can take that. Usually, the project manager cannot be able to resolve it, can take it to the board, and the board can make uh, can give advice, or can even be able to handle the conflict through mediation. Do you understand? But if in case they are not able to handle and resolve the conflict, of course, you can approach arbitration and see how you can resolve the conflict. Do you understand? So, review board is also there to help you. Then in healthcare, we have what we call mediation with expert input. Mediation with what? Expert input. Because this is not an ordinary sector. Do you understand? So you must bring experts in the healthcare to give their input for you to be able to mediate. Or you can get professionals who are medical doctors but have mediation, alternative dispute resolution skills. That's why when it comes to conflict resolution or conflict management or conflict exists everywhere. Do you understand? No institution is devoid of conflict. Do you understand? No institution is immune to conflict. No profession is immune to conflict. No, none. There's none. That's why this field is very, very important. This particular field is very important because no institution is immune to conflict. So in medical sector, we are seeing we see conflicts. Do you understand? Have we not seen medical doctors who on strike? In our own situation here, say is their nature. Do you understand? So it's conflict is everywhere. So mediation with expert what input. So in medical malpractice cases, mediation can incorporate expert opinions to facilitate understanding and resolution before moving to arbitration if needed. So if there are any form of medical malpractices here and there, how do you resolve it? How do you address them? Do you understand? So mediation can be included, but you can bring experts who understand the field and what is involved to give their input. It's the input they give that you can be able to use to mediate. And the good thing about it is that even the medical professionals can also be experts in arbitration. Do you understand? Some of them may have knowledge of this field and they can be able to mediate very well. Do you understand? So that's what it means. So, and like as I'm talking to you now, if I'm a medical doctor here, you can, because of the knowledge you gain here, you can be able to mediate. Do you understand? You can be able to mediate. So, environmental disputes. So here we have consensus building processes. So yesterday we discussed some of the group decision making techniques and consensus building techniques. All right, yesterday, right? I hope you are not forgotten. So now parties may engage in facilitated discussion to reach a consensus on environmental issues, then use mediation or arbitration to finalize agreement legally. Do you understand? So that's it. So once you have arrived at what you want through consensus or through consensorship, you can be able to now use mediation or arbitration to draft the agreement, to write the agreement, to document what you have agreed upon. So that's what it means. We talk about community conflicts. Community conflicts. So those of us that are in communities where conflict is everywhere, talking about community conflicts. How do you apply this? We talk about restorative justice. Restorative what? Justice. So in community disputes, a combination of mediation and arbitration can help address grievances while focusing on repairing relationship and community harmony. So that's why I don't believe in jungle justice. Right? If somebody, most especially in community situation, in community settings, where maybe young people are doing things that may not be encouraging, instead of taking to jungle justice, let there be mediation process and let young people be disciplined appropriately who misbehaved. Do you understand? Rather than Because as I'm talking to you now, in my village, something happened some times ago. Some young people, they were misbehaving, stealing, and then one day they went and stole a particular lady. The lady used to say some of these spices and all of that, like pepper, onions, and all of that. So, and then after a market day, in the midnight, they went out for operation, kidnapped this girl, took her to a particular forest, maltreated her, collected the money, and then, so in the process, while this thing was happening, people take note of what was going on. So they call for vigilantes and the young people in the community. And then what happened? So when those guys finished their operation, they were monitoring their movement, but they didn't know. So when they finished their operation and returned, they went and uh, sleep in one room, in one of their friends' rooms. They went there, all of them sleep, went and sleep there. So and then all the community, the vigilantes and the young people, the youth, gathered the house round. They called them to come out. So they came out. At the end of the day, they arrested them, took them to the market square. And so, in a process of trying to interrogate them, ask them questions to know where they were, and where, and why are they in the same place, in the same room, and all of those things. So in the process of doing that, one of them just the money they collected from that girl, he wanted to use the money to, as if the community he just want to run and then started praying the money. The community people grabbed them. The three of them were burnt alive, like three. They grabbed the next thing was tires and fuel. They burned three of them alive. Is that what we want? No, we shouldn't be doing that. You understand? That is jungle justice instead of restorative justice. We should be able to discipline. They would have collected the money, returned the money to the gear, and then whatever they did to the gear, medical issues, they would have handled it, and then or their parents handle such issues. Do you understand? Somebody will see a goat in a community and then they burn the person alive. How? Collect the goat, return it to the owner, and then let the young man or the person, the criminal, be cautioned. Do you understand? That's how to build communities. It's not by jungle justice. All right. So that is the issue. So restorative justice is what we need. It's not jungle justice. All right. So in a community where there are community conflicts or issues, let's use restorative justice to address them. All right. So what are the benefits of hybrid ADR processes? What are the benefits of hybrid ADR processes? Flexibility. Parties can choose the most suitable methods at each stage. To try arbitration and mediation, it didn't work, you can try arbitration. Try negotiation, it didn't work, you can go to mediation. And if it did not work, you go to arbitration. Do you understand? So it's flexible at whatever level and stage of the dispute. Efficiency. Combining methods can reduce time and cost compared to litigation. All right. So you combine elements of mediation and arbitration. It save you time, save you cost as well. Then preservation of relationships. Yes, of course. Approaches like collaborative law, mediation, they aim at preserving relationship. Even restorative justice, they aim at what? Preserving relationship. See what I'm telling you here now, the story I just told you now, in my community, they are just waiting for, because when that thing happened, it sent strong signals to young people, but at the same time it created enmity. You understand? There is a feeling of enmity in on ground is there. They are just waiting for an opportunity to come one day. Maybe a similar incident should happen. Maybe a young person steals something or does something, do you understand? They will also burn the person alive simply because it has happened before. So there should not be an exception. Do you understand? So this is what is in the community right now. So if you misbehave, possibly you may receive the same treatment because it has been done before. And then you'll be setting precedents that are not good. Do you understand? So there will be no a room for forgiveness. So somebody does something wrong, the next thing they kill the person, Abi. So there's no room for forgiveness anymore. So that's why we must use restorative justice. It preserves relationship and it builds community. Do you understand? It builds community. Also, we'll talk about mediation, collaborative law, family laws. Do you understand? This aims at preserving relationship. You have close relationship. You don't want this relationship to do so on account of disagreement or on account of business misunderstanding. No, you don't want the relationship to be destroyed. So you deploy the tool of mediation, negotiation, um, collaborative law, and restorative justice to make sure that the relationship continues. Do you understand? So it's one of the benefits of hybrid ADR processes. We also talk about tailored solutions. Parties can create solutions that are more specific to their needs rather than adhering to rigid legal frameworks. Do you understand? So these are some of the things that help to benefit the process. All right. So we let's look at some of the uh, case studies. All right. We're going to look at case studies showcasing successful uh, hybrid ADR implementations. Are there case studies? Are there areas where these approaches have been applied and they work successfully? That's what we want to look at. Are there such case studies? All right. That's what we want to look at now. So case studies that showcase successful implementation of hybrid alternative dispute resolution processes across different fields. One, we look at commercial dispute resolution, and we see where mediation and arbitration was applied in construction project. So we are going to read the case study so that you hear how it was being applied. Do you understand? Case study: a large infrastructural project. A large what? Infrastructure project. So in a major infrastructure project, a construction company faced disputes with subcontractors over delays and cost overruns. Do you understand? Now, in large construction, for those of you that does such kind of project, you understand what it means. That okay, you give maybe 100 uh, meter road construction, right? Or like this one that they have given coastal construction road that they gave about 15 trillion or whatever. Do you understand? So this kind of contract, it means that the company they assign this contract may subcontract it to other companies to help in the construction process. Do you understand? So now what happened here is that the main contractor is having problem with subcontractors. Why? Because they delay and then overrun costs. Do you understand? So additional costs added because of certain delays here and there, either by the main company delays or the delays by the subcontractors, whatever. But there's a delay. Do you understand? Now, so and they say that the constructor or the project, a construction company faced disputes with subcontractors over delays and cost overruns. So initially, the parties engaged in mediation, which allow them to discuss their concerns in a structured environment, which allow them to discuss their concerns in a structured environment. When mediation stall, they agree to transition to arbitration. That is made out. Do you understand? Mediation, arbitration. All right. So the mediator became the arbitrator. The mediator become what? The mediator became the arbitrator, which helped maintain continuity and trust, which helped to to maintain what? Continuity and build also trust. All right. So as a result, the parties resolve the issues efficiently, avoiding prolonged litigation and preserving their professional relationship. So you see, this is a situation whereby when we say the mediator became an arbitrator, it may be confusing to you, but it shouldn't be. Do you understand? Now, the problem is that the person who was assigned to be a mediator allowed the parties to make their own decisions that will help them to discuss and resolve their own problems. He was just facilitating the process. He had no authority over them. He cannot make suggestions. He cannot do anything. He cannot take decision for them. Do you understand? So he allowed them to discuss, and they were unable to resolve their problem. And then they say, well, since we're unable to resolve our problem, let's try arbitration since it's part of the process. It's one of the clauses in the agreement. Let's try arbitration. So automatically the person who was now a mediator can become an arbitrator if he has the experience. Do you understand? So, and what does that mean? It means that because they have discussed the issue and he was being the mediator, facilitating the process, he has an in-depth understanding of the problem and he can be able to help them take decision, a binding decision. Since they cannot be able to resolve their own problem, he will help them to resolve it. So he will take a decision that is binding on them, and we say that this can build what? Trust, because this person was involved in the facilitation process and did not interrupt it, did not take side. Do you understand? And now they are moving into arbitration and they are making him an arbitrator because they can trust him, so he can go ahead and take the decision. Do you understand? He can go ahead and take decision, and the decision will be binding based on what he had. And of course, that will save them time. I hope you understand the reason why they say the mediator can become an arbitrator. Do you understand? Automatically. Yes, I hope we are not confusing ourselves now. All right. So family law, family law. So let's see a case study where this works well. Collaborative law approach. That's case study. Divorce settlement. Divorce settlement. All right. In a high conflict divorce, both parties opted for a collaborative law involving lawyers and a neutral mediator. Involving what? Lawyers and a neutral mediator. So they had a series of meetings to negotiate asset division and child custody. They had what? Asset division and child custody. That's maybe they have a child arrangement. So when discussion reached what? An impasse, they agreed to binding arbitrations on specific issues, allowing a quicker resolutions. So this hybrid approach enabled the couple to maintain a civil relationship for co-parenting rather, while reaching a fair settlement. All right. So at the end of the day, all of them agree that, well, we are not enemies, just that we cannot journey together anymore. Do you understand? But not that we are enemies, but so far as the journey of marriage is concerned, We cannot journey together, but you give me what I can go and take care of myself. You to have what you can take care of self. And then both of us can put effort together to look after our child. So the child may decide to stay with you, who may stay with me. Do you understand? And one may be visiting from time to time, as the case may be. Some do like this, visit they remarry again. Do you understand? they, they do like this, they revisit until they marry again. So that is what that is what it is. So, but there's a fair settlement. Do you understand? So because one, we say that collaborative law, the essence of collaborative law is to preserve relationship, right? And then we say that in case it didn't work, but it does not mean that it did not work totally. It may work on certain aspects, but there are certain aspects that arbitration can work better. Do you understand? So you bring the aspect of arbitration that will work better, and on those issues that you consider that arbitration can function better, and then you place it there, and then you enforce collaborative law in other areas, which is what you see in this case now. That is the issue of co-parenting is more or less of a kind of preserving a relationship. Do you understand? You don't want to separate the child from both parents. So the relationship is preserved. And that's the essence of collaborative law. Whereas the division of properties was done. Do you understand? Division of properties was done, but relationship preserved. I don't know that you understand this the what is involved here now. So and we can consider that to be a successful case study. Do you understand? So workplace dispute, facilitated negotiation, case study, union negotiations. So a labor union and management face a stalemate during contract negotiations. They invited a neutral facilitator to help them to, identify common ground. They invited a neutral facilitator to help them to do what? Identify common ground. When initial negotiation failed to yield results, they moved to a mediation. They moved toward a mediation phase with the facilitator assisting. So if mediation did not resolve all issues, they agreed to arbitration for unresolved matters. This hybrid approach led towards a successful contract agreement without the need for a costly strike. This is what we have not been able to apply here very well, that we're always on long strike. In those days, it was even bad. Some people went to school for the course of 4 years. They spent 6 years. Do you understand? Because of disagreement, because of the inability of the parties involved to be able to resolve the conflict as supposed to. So you can decide to deploy the hybrid approach here to resolve the conflict. First, negotiation. If negotiation did not work, you can go into mediation. And what we always have here, is more of negotiation. What we always have is, so you discover that they continue to negotiate and negotiate and negotiate. There's no mediation. At some point, you see people like Falena, they were trying to call me to, mediate, but much was not, attention was not given to them. Do you understand? So these are the issues. So they don't welcome mediation much. Do you understand? They just focus on negotiating. We're still negotiating with the government. As we're negotiating with the government, and they are negotiating until it ends in strike. So if negotiation does not work, move to mediation. Do you understand? And if it did not work, move to what? An arbitration. Shouldn't be difficult, but lack of sincerity, lack of honesty, lack of concern for people make these things become so difficult. You understand? So let's look at international trade dispute, multi-tier clauses case study, cross-border business dispute, cross-border what? Business dispute. Two companies engaged in international trade encountered a dispute over contract terms. The agreement included a multi-tiered dispute resolution clause requiring negotiation first, followed by mediation, and finally arbitration if necessary. After unsuccessful negotiations, they proceeded to mediation, which brought in expert opinions on trade practices. When mediation failed, arbitration resolved the remaining issues, effectively demonstrating the benefit of structured hybrid approach. So what we are saying here is simple. The truth of the matter is that when we say negotiation failed, it did not mean that negotiation failed totally. Do you understand? But there are certain elements of the contract or of the issue that negotiation could not be able to handle. And of course, mediation also may not be able to handle certain issues. And then arbitration may be deployed to finalize the whole process. Do you understand? So, and that's the reason why you must have the three of them, most especially when it has to do with cross-border issues. Do you understand? Have the three of them as clauses in your contract so that in case there's any issue, you can deploy the three of them to resolve your differences. So it's very, very important. So in healthcare, mediation with expert input, case study, medical malpractice claim. So in a medical malpractice case, the patient and healthcare provider opted for mediation with the involvement of medical experts. The mediation session facilitated open communication about the incident, allowing both sides to better understand each other, to understand each other's perspective. When mediation did not produce a resolution, they proceeded to arbitration, where the expert insights play a crucial role in reaching a fair settlement, reducing the time and stress associated with the litigation. So the issue here is that when we talk about expert input, okay, you may not necessarily be a medical doctor, but you can invite experts to come and maybe discuss on the issue of uh, family uh, family health cares, whatever. So maybe let's say family planning go wrong, right? So you want to find a solution, and then maybe there was an issue. There's dispute here and there. So you may not be a doctor who specializes in family planning issues. So, but he's there to mediate or to facilitate, and then he may decide to invite experts who are specialists in the field to come on. So that we know where the mistake and the problem is coming from. What makes this to fail? Is it the fault of the doctor or who inserts the family planning instrument, or is it the misuse of the inserted equipment or whatever? So you an expert may come and explain their own. So you, the mediator, who maybe became an arbitrator, can, based on what you heard, based on the expert explanation, you can determine a judgment. A decision can be made. Do you understand? And that decision will be binding. Talk about environmental conflict, consensus building, case study, community environmental dispute. A community faced an environmental concern from a proposed industrial development. The stakeholders engaged in a consensus building process facilitated by a neutral party. When discussions reached a deadlock, they shifted to mediation, where specific environmental impacts were addressed. All right. Ultimately, an agreement was reached that included mitigation measures, showcasing how a hybrid approach can foster collaboration. Do you understand? So that is what happened. So that is what happened. So very, very important. So the parties may come discuss, wow, okay, that's good. You want to establish something for us here, but what about the environmental impact that we are trying to avoid? Do you understand? So all of this can be discussed. Do you understand? They can be discussed, and then a solution can be provided. So these are some of the case studies, and so if you can apply this hybrid ADR processes in this manner, then it can work well. It can work well. It can bring success in dispute resolution. So let's try to see the evaluation of these issues that we're talking about here. Evaluating the effectiveness of hybrid approaches in achieving resolutions. So let's conduct an evaluation. Let's see how these things work effectively, all right, or otherwise. So evaluating the effectiveness of hybrid alternative dispute resolution approaches involves examining various factors that contribute to successful outcomes. So what are those areas that we're going to look at? So we're going to look at resolution rates. Resolution rates. Do you understand? So success in reaching agreement. Success in reaching what agreement? A high percentage of disputes resolved through hybrid approaches indicates effectiveness. For instance, many commercial cases using that is mediation arbitration, report resolution rate exceeding 80%. 80 what percent? Let me tell you, some of the disputes, most especially some banks now, they are not going to court to go and resolve their issue. They use ADR. Do you understand? They're using ADR. I know one of our member who is based in Benin. He comes to Abuja frequently for ADR activities. Do you understand? I know him. Some of these banks, some of these agencies, they use ADR to resolve their issues instead of going to court. So 85% or 8%. Time efficiency, duration of the process. Hybrid approaches often reduce the time taken to resolve disputes compared to traditional litigation. Of course, for example, mediation followed by arbitration can expedite resolution with many cases concluding within months instead of years. Many cases, many cases can be resolved in months rather than years. So cost effectiveness, lower legal cost, right? Yes, lower what? Lower legal cost. We talk about satisfaction of parties, stakeholders' feedback. Surveys and interviews with participants can reveal satisfaction levels regarding the process and outcomes. Many users of hybrid ADR report higher satisfaction due to their involvement in crafting solutions because you participate in producing the solution. And you cannot produce a solution and you yourself turn and be dissatisfied. Yes, of course, sometimes you can produce a result may not be totally what you wanted, but to some extent, you appreciate your effort for not going home empty-handed. Do you understand? At least you go home with something. At least you go home with what? Something. So at least to some extent, you will be satisfied. You know, when I was feeling like this today's class will not hold, I was feeling somehow. I came in, uh, I was looking at it. Should we just cancel today's training totally? Oh, I should reschedule it. I was just so I didn't have time to bargain it with you people to ask you a question. Should we cancel it? Should we reschedule it to a later? Or I just contemplated within me, conflict, intra conflict. That's in conflict within myself. You understand? So at the end of the day, I say, well, let's reschedule. Those that may connect, and I'm surprised a good number of you still connect. You understand? So it shows that I did not make wrong decisions. You understand? So to some extent, I feel happy that we did not postpone today's class because we have a lot to cover and we have limited time. So we just needed not to postpone this class. You understand? So that's what it is. So prevention of relationships, impact on future interaction. Impact on future interaction. Hybrid approaches often foster better relationship among parties. The collaborative nature of mediation combined with the finality of arbitration tends to maintain or even enhance professional relationship post dispute. So this is what it means. So preservation of relationship is also one of the things that these hybrid approaches help you to achieve. Flexibility and customization, right? Solutions are being tailored to suit what the participant want, the parties involved want. Do you understand? So you're not going to go and manufacture resolution from somewhere. You're not going to impose, and where it is even being imposed is not imposed unfairly. Do you understand? That's when an arbitrator take the decision. At the end of the day, it is still based on what you people have said that make him to take a decision that may not necessarily favor both parties. So quality of outcomes, fairness and acceptability. That's what I'm saying. Fairness and what. So at the end of the day, the decision being taken, even if you lose, at least you see some element of fairness in it. Do you understand? Unlike if you go to court now, court will pronounce judgment, 20 years imprisonment, and maybe an arbitrator may give like some kind of fine to pay, and then you'll be a free person. Do you understand? So that is what it means. So fairness and what acceptability. Reduction of litigation, it reduces chances of going to court very well. Let's say by 70% reduction of litigation. Adaptability to diverse contexts. So it applies in different situations. Applies in what different situation, family, commercial, environmental, all of these they are being applied there. Post-resolution compliance, adherence to agreement, monitoring how well parties comply with agreement reached through hybrid approach can serve as an indicator of the process effectiveness. Do you understand? So compliance has been so good. All right, have been so good. It's just that in our environment here, even when court cases are not being followed, I don't know, arbitration will struggle, but it will still works, still works. That's why those that knows it very well, sometimes they go to MDRM, that is Brekete family for enforcement of their whatever, whether it's an arbitration result or a litigation outcome. They take it there for enforcement. They understand, and it can be enforced. This is the much we are going to take for today. I really appreciate you and your time. So training so that we will not go beyond what we're supposed to go. It's already uh, it's already to 9 already. So I don't want us to go far beyond this. All right. So are we together? So like I said before, those of you that did not pass your emotional intelligence results or exams, we are going to you are going to write your exams by tomorrow. So by tomorrow 9 p.m. So make yourself available. Instruction will be guided on how you are going to get the link for your exams. And then the grouping for our simulation is going on. So we share the topics and the groups so that on Thursday we'll start. And then for those of you that are intending to give me gifts, because some people reach out to me and they want to give me gifts, I appreciate it. And thank you for your consideration. Thank you for your heart of appreciation for everything we are doing. Uh, we're not looking for it, but you just look in your heart. You feel that you should do something for us. We appreciate it. And we pray that God will continue to empower you um, to have such a good heart. So we appreciate those of you that are getting interest to do something for us. We are grateful. Thank you very much. And whatever you do for us, whether to me or to the institute, you know, it will be much appreciated. So thank you very much. We are grateful. We are grateful. Thank you. So we will meet on Thursday. Tomorrow is our free day. So but we'll meet on Thursday for our training. We'll continue from there on Thursday where we'll stop. So thank you very much. We appreciate you and your time. See you on Thursday.